Hello friends, welcome to EPG Pathshala. Today we are going to discuss joint criminal liability. Before going into the topic, let me introduce myself. I am Mr. Ramakrishna Das PR, Assistant Professor of Law from National Law University, Odisha. As you know, the universal law is that every man is responsible criminally for the wrong committed himself malafidely, or in other words, no man will be held responsible for the independent act of wrong committed by another. It is thus accorded that the primary responsibility is of the person who is actually commits the crime, and he will be guilty for the same and shall be punished in accordance with law. However, the implication comes only when several persons are involved in commission of an offence in different capacities. Let us say one is the actual offender and rest are facilitator. In such cases, a distinction should be drawn the act of each of such individual according to their mode and degree of participation or involvement in the commission of the offence for ascertaining guilt and awarding punishment. Such persons are broadly classified into principal and abettors. When two or more persons are involved either jointly or in group, and it is not possible to apportion criminal guilt of each of the participants, all the participants are held jointly liable for the offence committed by one or all the members of the group. This is based on the principle that the presence of accomplice gives encouragement, protection and support to the person actually engaged in the commission of the unlawful act. The doctrine of group liability is justified on common sense principle that if two or more persons do an act conjointly, it is just the same as if each of them has done it individually. And before going to the subject, let us understand what are the learning objectives in this subject. The basic, the first and the foremost principle behind this module is to understand the concept of joint liability in general, and the second expected learning outcome is to understand the concept of joint liability in criminal law particularly. To understand the third objective is to understand the difference between the common intention and the common object. And the last learning outcome is to understand the application of section 34 and section 149 of the Indian Penal Code. Now, before going to the vicarious liability under criminal law, we should know whether the concept of vicarious liability has been recognized under law of torts. Yes, it has been recognized under law of torts. The vicarious liability under the law of torts imposes responsibility upon one person for the tort committed by the another with whom the person has a special relationship to exercise such care as a reasonably prudent man would use under similar circumstances. The most common form of vicarious liability is when the employers are held liable for the tort committed by the employee. Some of the instances of such liability are liability of a principal for the tort committed by the agent, liability of the partners of each other's tort, liability of the father for the tort of his child, etc. And let us discuss the joint liability under civil law. You will be really amazed why the concept of vicarious liability has been brought into the concept of law of tort or under the criminal law, right? But the history speaks that the liability for such an imposition was because of the slavery system that was existed in our country long back, and it was considered that because in the slavery system, and you know very well that the slaves are considered as the property of the master. Hence, if any tortious act committed by the slaves, whether with or without authority, it is presumed the same was committed as per the instruction of the master. By the end of 17th century, the concept of vicarious liability was found inadequate due to rise in commercial transaction. New development took place when Sir John Holt in case of Tuberville vs. Stem held that the master would be liable for the servant's tort if he had given his implied command. Hence, we can say the modern theory of vicarious liability is propounded by Sir John Holt. However, the modern concept is not on the basis of the slavery concept, but it is on the basis of the two important principles. This is a very important two important principle. And the first principle is respondent superior, which literally means what, let the principal be held liable, right, or let the superior make answer. It provides a better chance to the victim to claim appropriate damages, because under this principle the employer or the principal is liable for the injuries caused by an employee agent who is working within the scope of his employment relationship. The theory behind the principal controls the agent's behavior and must then assume some responsibility for the agent's action. And the second important principle, this is also very important principle, this is considered to be the backbone of the concept of vicarious liability under law of torts. Q facit alium facit per se. It means who acts through another does the act himself. It simply says that the principal is personally liable for the negligent act committed by the agent during the course of employment. The principal's tort liability is based not on agency but on the relationship of master and servant expressed in the maxim respondent superior. Apart from these two principles, right, there is one more principle which the master is held responsible, right. It says that the liability attached to the person for the wrongs committed by the others may arise on two circumstances, two such as liability by ratification and liability by abatement, right. When a person commits a wrong while acting on behalf of another but without his authority, and that the others and the master subsequently ratifies that act, he thereby becomes responsible for it. And this principle is on the basis of the maxim that is omnes rati habitio retro hertent mandato prior accuperator, which means ratification relates back and thereupon becomes equivalent to previous request. In actions of tort, those who abet the tortious act are as much as liable as the tortfeasors themselves. And there is another important test which is connected to vicarious liability is close connection test. This theory was propounded by Salmond, which is on the basis of the nature of act done by the servant. And one of the important element is that if the servant is liable if the act is done during the course of employment. Perhaps this concept is the most vexed requirement, as has often resulted in the decisions which are inconsistent or irreconcilable, leading observers to suspect that many decisions were really based on court's perception of what justice required. An early yardstick used is that the Salmond test of authorized and unauthorized act. If the act was authorized but the mode was unauthorized, the act was nevertheless done in the course of employment. However, the Salmond test, though generally helpful, had its limitations, and various other tests or factors were introduced, including the other factors are, first one is the degree of excessiveness of the employee's conduct. This is very important. The second point is the employee's motive. That is also very important. The third one is the scope of the employee's authority and whether the conduct benefited the employer. So, these four principles also we have to read along with the tortious vicarious liability. Even with all the tests, the court had difficulty in dealing satisfactorily with cases of intentional tort, such as instances of sexual abuse in welfare homes. In Lister versus Hesley Hall, the House of Lords held a boarding house vicariously liable for the sexual assault committed by the warden on children in the care on the basis of the close connection between the employee's nature of employment and the tort he committed. In doing so, he overturned the Court of Appeal's decision in Tortman versus North Yorkshire, which had applied the Salmond test and held a school is not vicariously liable for the sexual assault committed by its deputy headmaster. In Lister, the House of Lords choose instead to follow the head of the Canadian Supreme Court in Baseley versus Curry. The advantage of a close connection test, as Lords Millet observed, is that it would accord with the underlying rationale of the doctrine of vicarious liability and be applicable without straining the language of Salmon test to accommodate cases of intentional wrongdoing. Next, we will discuss the joint criminal liability under the Indian and the English law. The English legal system makes a clear distinction between the principal and the accessories. The principal is the person who actually commits the crime, and the later is the person who aids the principal for committing the crime. They are treated as accomplices and both will be held responsible for the criminal liability. The basic justification for the constructive liability. So, always remember the concept of joint liability will be also called as a constructive criminal liability. So, in the constructive liability, it is of twofold. The justification goes in twofold. Firstly, the offences committed in group give encouragement to the accomplice, and secondly, in offences committed in the groups, the job of the prosecution becomes difficult to ascertain the specific role played by each members of the group. Thus, in a case where two or more persons are involved, either jointly or in group, and it is not possible to apportion criminal guilt of each of the participants, all the participants would be liable for the offence committed by anyone or all the members of the group. This is on the basis of the doctrine of constructive liability, or on the doctrine of vicarious liability, or on the doctrine of what complicity of crimes. The complicity of crime under the Indian Penal Code. Under Indian Penal Code, we have a lot of provisions which deals with joint criminal liability. Let us say, for example, section 34 to section 38. It is a very important section in the Indian Penal Code. Then section 120A and 120B of the Indian Penal Code, section 149, 154, 156, 396, 460 of the Indian Penal Code. All these sections are dealing with what vicarious liability, or the joint criminal liability, or constructive liability, or the complicity of crime. Let us say section 34 to 38 deals with the joint liability on the basis of common intention. That is very important. Section 1, this term we are going to discuss what is mean by a common intention under section 34 to 38. Then under section 120 and 120B deals with joint liability of a member of a conspiracy to commit an offence. Section 149 deals with joint liability of a member of an unlawful assembly when an offence is committed in prosecution of the common object of unlawful assembly. So, another term which is called common object. So, first term which we used is common intention, and the second term under section 149 we are using common object. These two terms we will discuss later. And section 154 and 156 deals with the liability of the owner of the property where an unlawful assembly was held for conducting a riot. Section 396 deals with the joint liability of dacoits when a dacoit commits a murder for committing dacoity. Section 460 deals with joint liability of a person concerned in lurking house trespass or house breaking by night when death or grievous hurt is caused by one of them. Now, we will discuss about the liability on the basis of common intention. By virtue of section 34 of the Indian Penal Code, which says when a criminal act is done by several persons in furtherance of common intention of all, each of such a person is liable for that act in the same manner as if it were done by him alone. 34 is one of the section contained in the chapter 2 of the Indian Penal Code, which is headed as general explanations. It is one of the group of sections which have to be read together with section 32, 33, 34, 35, 37 and 38 in order to appreciate its full significance. As a matter of fact, section 35, 37 and 38 provide the background against which provisions of section 34 are to be judged. The Judicial Committee of the Privy Council has had an occasion to consider the scope of section 34 in Barendra Kumar versus Emperor and Mahmud Shah versus Emperor. In the former case, it was held that section 34 deals with the doing of a separate act similar or diverse by several persons. If all are done in furtherance of common intention, each person is liable for the result of such an act as he had done it himself. The act and then again it in the later part of the section must include the whole of the action covered by the criminal act. In the first part of the section, further the court added that the criminal act means the unity of a criminal behavior which results in something for which an individual would be punishable if it were all done by him alone, that is the criminal offence. In the case of Mahmood, the apex court held that section 34 of the penal code lays down the principle of joint liability in the doing of a criminal act. The essence of the liability is to be found in the extent of common intention animating the accused leading to the doing of a criminal action furtherance of such intention. To invoke the aid of section 35 successfully, it must be shown that criminal act complained against was done by one of the accused person in furtherance of common intention of all. Intention within the meaning of section implies a pre-arranged plan. This is a very important term with respect to section 34, right. So, it says that there should be a pre-arranged plan, and to convict an accused of an offence applying this section, it should be proved that the criminal act was done in concert pursuant to the pre-arranged plan. It is difficult if not impossible to procure direct evidence to prove the intention of an individual. In most cases it is to be inferred from his act or conduct or other relevant circumstances of the case. Care must be taken not to confuse the same or similar intention with common intention. The partition which divides their bounds is often very thin. Nevertheless, the distinction is real and substantial, and if overlooked will result in miscarriage of justice. The inference of common intention within the meaning of the term section 34 should, unless it is a necessary inference deductible from the circumstance of the case. In Raju versus State of Maharashtra, the Honorable Supreme Court observed that the provision is intended to meet a case in which it may be difficult to distinguish between the act of individual members of a party who act in furtherance of common intention of all, or to prove exactly what part has taken by each of the members, right. Section 34 is an interpretative provision which lays down the common sense principle that if two or more persons do things jointly, it is just the same as if each of them had done it individually. To attract the principle of joint liability under section 34, the following ingredients are necessary. First one is a criminal act which is jointly committed by the several persons. Second point is a common intention animating all of them in furtherance of which the criminal act is committed. The rule of joint liability under section 34, only a rule of evidence, does not create a specific offence, was held in Gurudatta Mal versus State of Uttar Pradesh. The liability of a person for an offence committed by another in the course of a criminal act perpetrated by several persons arises under section 34 if such act is done in furtherance of common intention of the person who jointly commits the crime. At the same time, if two persons commits the crime jointly but through independent act not in furtherance of any common intention, then remember section 34 has no application, right, because the act is done not in furtherance of their common intention, right. Again, the common intention should be shown to be premeditated. It must be shown that there was a prior meeting of minds which activated the common intention leading to the commission of the criminal act. However, in few cases which the common intention may develop on spot after the offenders has gathered. In order to invoke section 34, the Supreme Court has reiterated in numerous cases that common intention implies a pre-arranged plan, and it should be proved by the prosecution that the criminal act was done in concert pursuant to the pre-arranged plan. In Panduranga versus State of Hyderabad, right, it was the Honorable Supreme Court has held common intention under section 34 presupposes a prior concert. Accordingly, there must have been a prior meeting of minds. Several persons can simultaneously attack a man, and each can have the same intention, namely the intention to kill, and each can individually inflict a separate fatal blow, and yet none would have the common intention required by the specific section, because there was no prior meeting of minds to form a pre-arranged plan. In such cases, each would be individually liable for whatever the injury has caused, but none would be vicariously convicted for the act of any of the others, any of the act done by the others. And if the prosecution cannot prove that his separate blow was a fatal one, he cannot be convicted of the murderer. However, clearly an intention to kill could be proved in this case. Further, the Supreme Court again pointed out that prior concert need not be something always very much prior to the incident, but could well be or something that may develop on the spot, on the spur of the moment. In Kripal versus State of Uttar Pradesh, again the Honorable Supreme Court reiterated that common intention may develop during the course of occurrence and could develop on the spur of the moment. On the issue of common intention arising, suddenly the Supreme Court ruled that the common intention to bring about a particular result may develop on the spot, as between a number of persons, with reference to the fact of the case and the circumstances of situation. Whether in a proved situation all the individuals concerned therein have developed only simultaneous and independent intention, or whether a simultaneous consensus of their minds to bring about a particular result can be said to have developed and thereby intended by all of them, is a question that has to be determined on the facts. At this juncture, it would be more appropriate to look into the difference between the common intention and the similar and same intention. Right? The question was, what is difference between a common intention, a same intention, or a similar intention? This question was raised before the Supreme Court in Dakmochan Pandey versus State of Bihar. It was held that common intention which developed at the spur of the moment is different from a similar intention activated at a number of persons at the same time, and the distinction must be born in the mind, which would be relevant in deciding whether section 34 of the Indian Penal Code can be applied to those who might have made some overt act on the spur of the moment. Right? The distinction between the common intention and a similar intention may be fine, but nonetheless, the real one hand, if overlooked, may lead to miscarriage of justice. It is necessary that intention of each one of the several person be known to each other, or it must be shared between for constituting what a common intention under section 34. Same intention of several persons does not what constitute common intention under section 34 unless it has been shared among the accomplices. That is very, very important in order to invoke section 34 of the Indian Penal Code. Hence, in cases where all persons having same or similar intention are physically present at the same time and at the place where the offence is being committed, are jointly responsible for the offence committed, each one will be liable for his act. And also, mere presence of accused together is not sufficient to hold the presumption that they shared the common intention to commit the offence in question. In Jai Bhagavan versus State of Haryana held that in order to invoke section 34, apart from the fact that there should be two or more accused, the two factors must be established. The first one is that is common intention, and the second one is participation of accused in the commission of the crime. So, these two essential ingredients are necessary in order to invoke section 34 of under Indian Penal Code. If the common intention is proved, but not the overt act is attributed to the individual accused, section 34 will be attracted as essentially it involves vicarious liability. But if the participation of the accused in the crime is proved and the common intention is absent, then section 34 has no application. That is very important. Next, we are going to discuss a comparative analysis of common object and common intention. Common intention we know right very clearly. Now, what is the relationship between this common object and common intention, which is kept under section 34 and section 149 of the Indian Penal Code? Let us go for a comparative analysis of these two concepts. Section 149 of the Indian Penal Code, chapter 7 of the IPC deals with offences against public tranquility, creates a specific offence and declares that a member of an unlawful assembly is liable for any offence committed by the other fellow members in prosecution of the common object of that assembly. The essentials of this provision are: there must be an unlawful assembly, right? The offence must have been committed by one or other members of the assembly in prosecution of the common object of the unlawful assembly. The offence must be such as the members of the unlawful assembly knew it to be likely to be committed in prosecution of the common object. So, however, it doesn't mean that the members of an unlawful assembly is answerable for every act committed by the fellow associate during the time they engaged in the commission of the offence. It is only in two cases where a person is held criminally liable for the offence committed by the other members of the unlawful assembly. Firstly, where the offence is committed in prosecution of the common object of the unlawful assembly, and secondly, where the members of the unlawful assembly knew that such an offence is likely to be committed in prosecution of common object. The essence of joint liability under section 149 is that, is very important, the criminal act must have been done with a view to fulfill the common object of an unlawful assembly. If the prosecution fails to prove that the act has been done in prosecution of the common object, the member of an unlawful assembly cannot be held liable for the offence committed by another member of such an assembly or under section 149 of the Penal Code. Right? In Nanak Chand versus State of Punjab, the Supreme Court observed that there is a clear distinction between the provision of section 34 and 149 of the Indian Penal Code, and two sections are not to be confused. The principal element in section 134 of the Indian Penal Code is the common intention to commit a crime. In furtherance of common intention, several acts may be done by several persons, resulting in the commission of that crime. In such a situation, section 34 provides that each one of them would be liable for that crime in the same manner as if all the acts resulting in that crime had been done by him alone. There is no question of common intention in section 149 of the Indian Penal Code. An offence may be committed by a member of an unlawful assembly. The other members will be liable for the offence, although there was no common intention between the person and the other members of the unlawful assembly to commit that offence, provided the conditions what are leading down in section are fulfilled. Thus, if the offence committed by the person is in prosecution of the common object of unlawful assembly, or such as the members of that assembly knew to be likely to be committed in the prosecution of common object, every member of an unlawful assembly would be guilty of that offence, although there may have been no common intention, no participation by the other members in the actual commission of that offence. In Chittarmal versus State of Rajasthan, the apex court held that there is a clear distinction made between the common intention and the common object, is that the common intention denotes action in concert act and necessarily postulates the existence of a pre-arranged plan implying a prior meeting of minds, while a common object does not necessarily require proof of prior meeting of minds or pre-concert, though there is a subsequent difference between the two sections. They also to some extent overlap, and it is a question to be determined on the facts of each cases. Next we will discuss the exact difference between section 34 and section 149 of the Indian Penal Code. Let us say for under section 34 of the Indian Penal Code, in common intention number of persons must be more than one, but it is not compulsory that the number of members should be 5, right. But whereas in the case of common object under section 149, that it says that there must be at least 5 members in order to invoke section 114. So, that is the first difference. The second difference is common intention does not create specific offence, but only a status of rule of evidence. But whereas in the case of common object under 149, which says it creates a specific and substantive offence. The third difference is under section section 34, it may be of any type, but if you discuss under section 149, it must be one of the object mentioned in section 145, that to commit an offence under such object. And the fourth difference is under section 34, prior meeting of mind is necessary before a wrong act is done under this section. It requires that all the accused must meet together before actual attack participated by all takes place. And while under section 149, prior meeting of minds is not mandatory, mere membership of unlawful assembly at the time of committing crime is sufficient. And the last difference, and very important one, is only offence committed under section 134 is in furtherance of common intention is punishable, whereas under section 149, members of unlawful assembly under this section are not only liable for an act done in prosecution of common object to be done in prosecution of unlawful object. Let us conclude. The entire object behind the concept of constructive liability is to punish the entire accomplice who aids to commit crime either jointly or individually. The relevance of this provision can be better understood if we think about the non-inclusion of section 34 and 149 in the Penal Code. Initially, there were a lot of ambiguity around section 34 and 149, which was removed to an extent by the Privy Council in the Barendra Kumar Ghosh case. Later, the first Law Commission report also recommended adding 2 or more persons instead of several persons to section 34. It helped for a better understanding of this provision. The underlying object of criminalization of unlawful assembly under section 149 is to discourage tumultuous assemblage of person to preserve public peace. It has been retreated by the Supreme Court that the presence of the accomplice give encouragement to the actual offender to commit the offence, and in such a case the accomplice cannot be exempted from the criminal liability. This is not the only idea behind section 149, but also the entire concept of joint liability springs on this idea. Thank you for watching this video. Hope this lecture would help you in many ways.